If you have any immigration application pending with USCIS right now, or you're about to file one, a policy that changed just 2 days ago could mean the difference between an approval and an outright denial, with no warning, no second chance, and no request for missing paperwork. Welcome back to US Visa News Hub. I'm Mr. Burhan, and if you're not subscribed yet, this is exactly the kind of update you don't want to miss. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. On August 5, 2026, USCIS issued a new policy update, officially titled Reinforcing Evidence Standards, that fundamentally changes what happens when your application is missing something. This policy took effect immediately, and it applies not just to new filings, but to cases that are already pending right now, sitting in USCIS's system, unless a specific regulation says otherwise. So if you filed something months ago and you're just waiting to hear back, this change already applies to your case today, whether you knew about it or not. Here's the core of what changed and why it matters so much. Under guidance USCIS had followed since 2021, officers were generally directed to give applicants a chance to fix a problem before denying a case. If required evidence was missing, or if the filing didn't clearly establish eligibility, the standard practice was for USCIS to issue a request for evidence, commonly called an RFE, or a notice of intent to deny, called a NOID, giving the applicant an opportunity to submit what was missing before a final decision was made. That built-in safety net is now gone as the default approach. Under this new guidance, if a filing does not establish eligibility or if it's missing required initial evidence, meaning the specific documents listed in that form's own instructions, USCIS can now deny the case outright, immediately, without ever sending an RFE or a NOID first. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. I want to be clear about something important here, because a lot of people are going to misunderstand this policy in one of two directions, and neither is quite right. This does not mean USCIS has stopped issuing RFEs and NOIDs altogether. Officers can, and still do, send them when they consider it appropriate. What's changed is the default assumption. Previously, an incomplete filing almost automatically earned you a chance to fix it. Now, that opportunity is no longer guaranteed. It's entirely at the officer's discretion, case by case. USCIS itself has described this as restoring officer discretion, not eliminating the RFE and NOID process. And in fact, this isn't even a brand new approach for USCIS. It's essentially reviving a policy the agency used back in 2018, during the first Trump administration. Before that, 2021 guidance reversed it and made RFEs and NOIDs the standard practice again. So we're really looking at a pendulum swinging back to where it was several years ago, not something entirely unprecedented. So why is USCIS making this change now? In its official announcement, the agency framed this as a way to reduce what it calls frivolous, placeholder, and incomplete filings that slow down processing for everyone else waiting in line. USCIS specifically pointed to a pattern it says it wants to stop: people submitting bare bones or incomplete applications specifically to trigger related benefits, like employment authorization, while their actual underlying case sits unresolved and incomplete. In other words, the agency's stated reasoning is about efficiency and discouraging applicants from gaming the system by filing something incomplete just to get the clock started on secondary benefits. Whether or not you agree with that reasoning, the practical effect for everyone filing a complete, good faith application is the same. The margin for error at the moment of filing has shrunk considerably. Now let's talk about the second major piece of this update, because it's just as important as the denial authority itself: the actual response time you get if USCIS does decide to issue an RFE. Here's where I want to be precise, because some early coverage of this got a little confusing. The maximum legal response period for an RFE has not changed. It remains 12 weeks, or 84 days, and federal regulations still prohibit USCIS from granting any extension beyond that ceiling. What has changed is that 12 weeks used to be treated as the standard, default response time that most applicants could count on receiving. Under this new guidance, 12 weeks is now simply the outer limit, the maximum an officer is allowed to give, not what they're expected to give. Officers now have discretion to set a shorter deadline based on the type of evidence being requested and what USCIS calls the efficient operation of the immigration system. So in practice, you might receive an RFE with a response window of just a few weeks instead of the full 12 you may have been expecting based on how things worked before. There's a related change that specifically affects anyone living outside the United States when they receive a notice from USCIS. Previously, if USCIS mailed you an RFE or NOID at an address outside the US, you automatically received an additional 14 days added onto your response deadline to account for international mail delivery times. That extra 14-day cushion is gone. Now, only the standard 3-day mailing allowance applies, regardless of whether your address is inside the United States or somewhere overseas. If you're a consular processing applicant or anyone corresponding with USCIS from abroad, this is a genuinely significant reduction in the practical time you'll have to respond once a notice is mailed to you. There's one more detail buried in this update that's worth understanding clearly, because it closes a door a lot of applicants may not have even realized was open. Previously, if you submitted a response to an RFE or NOID that was incomplete, meaning it didn't fully answer everything USCIS asked for, there was sometimes an informal expectation that you might get another chance, or that the gap could be addressed later in the process. Under this new guidance, USCIS has clarified that if you respond to an RFE or NOID with an incomplete submission, the agency may simply treat that response as a request for a decision based on whatever is already in the record, meaning USCIS will decide your case on the evidence you actually managed to submit, gaps and all, rather than following up again. In practical terms, that means your response to an RFE needs to be treated as your one real shot to get it right, not a first draft you can build on later. Let's talk through exactly who this affects and why it matters so much in practice, because this isn't a narrow technical change limited to one visa category. It applies broadly across USCIS benefit requests. This affects green card applicants, whether filing based on family, employment, or another category. It affects people applying for work permits. It affects change of status and extension of status applications for people on temporary visas. It affects naturalization applicants. Essentially, if you're filing anything with USCIS, where the form instructions list specific required documents, and your filing doesn't include everything on that list, or doesn't clearly demonstrate that you meet the underlying eligibility requirements, you are now at real risk of an outright denial, not a follow-up request, not a chance to explain, but a denial, as your very first response from USCIS. Immigration attorneys reacting to this change have been fairly consistent in their message, and I think it's worth repeating clearly. The practical burden has shifted heavily onto applicants to get everything right at the moment of filing, rather than relying on USCIS to flag what's missing and give you a chance to fix it afterward. Boundless CEO Xiao Wang, commenting publicly on this update, made the point that applicants should no longer assume they'll have an opportunity to correct missing documents after submission, and that taking the time to file a complete application from the very beginning matters more now than it has in years. So, practically speaking, what should you actually do about this if you have a case pending or you're getting ready to file something new? First, and most importantly, go back to the official form instructions for whatever you're filing, not a summary you found online, not something a friend told you, the actual current USCIS form instructions, and check, line by line, that you have every single piece of required initial evidence included. Form instructions typically spell out exactly what documents are required, and under this new policy, those instructions are effectively being treated as the bare minimum standard every applicant is expected to meet on the very first submission. Second, if you have a case that's already pending and you're aware that something might be missing or unclear in what you originally submitted, this is a moment to talk to an immigration attorney proactively about whether there's anything you can still do to strengthen your file before a decision comes down, rather than waiting to see what happens. Third, if you do receive an RFE or NOID going forward, treat whatever deadline you're given as firm and final. Don't assume you'll get an extension, and don't assume a partial or incomplete response will buy you more time, because under this new guidance, it may simply result in USCIS deciding your case on an incomplete record instead. Fourth, if you're filing from outside the United States, build in extra time on your end for mail delivery, since you can no longer count on that extra 14-day cushion that used to help offset international mailing delays. It's also worth understanding what this change does not do, so you're not left more anxious than the situation actually calls for. This policy doesn't change the underlying eligibility requirements for any immigration benefit. The actual legal standards for qualifying for a green card, a work permit, or citizenship haven't changed. What's changed is the process and the margin for error at the filing stage. A strong, complete, well-documented application that genuinely meets the eligibility requirements is not suddenly at greater risk under this policy. The real risk here is specifically for filings that are incomplete, disorganized, or missing documentation at the time they're submitted. Given how recently this took effect, literally just 2 days ago as of this video, this is exactly the kind of moment where getting ahead of the issue matters far more than reacting after the fact. If you have any immigration application in progress right now, whether it's already filed or you're still preparing it, this is worth a direct conversation with a qualified immigration attorney to review your specific filing against the current evidence standards, rather than assuming the process will unfold the way it might have a year or two ago. We'll continue tracking how this policy plays out in practice over the coming weeks, including whether USCIS issues any further clarification on specific categories or exceptions. If this was helpful, share it with anyone you know who has an immigration case pending right now. This is exactly the kind of update that could genuinely change someone's outcome if they act on it in time. And subscribe to US Visa News Hub so you don't miss what comes next. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.